Okay. Good afternoon. Can everyone hear me? Yes. Okay, great. Are we ready to go ahead and go on the record? We good? Okay. No objections to that. Okay. So this is Women's Medical Group Professional Corporation et al. Versus Bruce Vanderhoff et al. Case number A2200704. We are set today here for hearing on plaintiff's second motion for preliminary injunction. Before we get started, I do want to just have everybody introduce themselves for the record. Let's go ahead and start with the defendants, if you want to identify yourself, and then just mute yourself again after you've identified yourself for the record.
Hi, I'm Amanda Narog. I'm representing the defendants in this case.
Thank you.
And I'm Andrew McCartney with the Ohio Attorney General's office as well, also representing defendants in this case. Thanks.
Is there anybody else here on behalf of the defendants? That's it. Okay. All right. Well, we'll move on to the plaintiffs then. Just go ahead and unmute yourself one at a time and introduce yourself for the record.
Good afternoon, Jessie Hill with the ACLU of Ohio on behalf of plaintiffs.
Fran Levinson, ACLU of Ohio, plaintiffs.
Good afternoon, Your Honor. Melissa Cohen from Planned Parenthood Federation of America for the Planned Parenthood plaintiff.
Okay.
Good afternoon. My name is Becca Kendis, and I'm with the ACLU Ohio for plaintiffs.
Good afternoon, Judge. My name is Kyla Eastling, and I'm with the Reproductive Freedom Project, ACLU, for the plaintiffs.
Thank you.
Good afternoon, Your Honor. Fernand Rucker here on behalf of Planned Parenthood.
Thank you. Is that everyone? Okay, great. And then for the defense, Ms. Narog, are you going to be doing argument?
Yes, Your Honor.
And for the plaintiff, there's Ms. Hill.
That's correct, Your Honor.
All right. Just preliminarily, I did receive and review the defendant's motion to dismiss, and in the alternative, their motion for summary judgment. I also received the plaintiff's reply to that motion. I've reviewed both of those motions and the reply. And I am at this time, the court's going to deny the defendant's motion to dismiss and also deny defendant's alternative motion for summary judgment. I'm going to put on an entry reflecting that decision that'll go on today. So I'll go ahead and let plaintiffs start with argument if everyone's ready to proceed.
Thank you, Your Honor. SB 157 prevents a physician who teaches or provides instruction directly or indirectly at a state-affiliated medical school or osteopathic school from serving as a backup physician for plaintiffs' variance applications. In addition, it also excludes from this role a physician who is employed by or compensated by or that provides consultation to a public medical school or osteopathic school. The plaintiffs have clearly shown here that they cannot comply with this new requirement and that they will lose their variances and therefore their ASF licenses, which means they will be forced to stop providing procedural abortions if SB 157 is enforced. This restriction violates the constitutional rights of the plaintiffs and their patients for three reasons. First, if enforced, SB 157 will infringe the plaintiff's patient's access to procedural abortion, and it is not narrowly tailored to a compelling state interest. As this court has already found in other cases, strict scrutiny applies under the Ohio Constitution to laws that infringe the right to abortion. The Ohio Constitution's protection of liberty under Article 1, Sections 1, 16, and 20, as reinforced by the language of Article 1, Section 21, the Ohio Healthcare Freedom Amendment, is broad enough to encompass the right to terminate a pregnancy, which is a fundamental right and therefore subject to strict scrutiny. The only interests advanced by the defendants in this case in support of SB 157 are first, an interest in avoiding public subsidies for abortion, which the defendants cannot show is a compelling interest. And even if it were, SB 157 is certainly not narrowly tailored to it. And then secondly, they've asserted a sort of general interest in health and safety. But even if this interest is compelling, the defendants haven't shown how a law that disqualifies highly skilled and qualified physicians from serving as backup doctors for ASFs could possibly promote the health and safety of patients or of the public rather than undermining it. SB 157 is unconstitutional for the second reason, that it also violates the fundamental liberty and property interests of the plaintiffs in their licenses, their ongoing businesses, and in pursuing their professions. Plaintiffs have cited extensive precedent showing, and this court has already found, that these are fundamental liberty and property interests under Ohio law. The cases that plaintiffs have cited, such as Asher Investments v. Cincinnati and State v. Cooper, are Ohio state court cases finding a state-created property interest under Ohio state law. Thus, again, strict scrutiny applies, and the defendants cannot show that SB 157 meets this exacting standard of scrutiny. In fact, Your Honor, they don't even try to show that SB 157 can meet strict scrutiny. And third, SB 157 violates the equal protection guarantee of the Ohio Constitution, both because it discriminates based on the exercise of fundamental rights, thus requiring the application of strict scrutiny, and also because SB 157 cannot even meet the less demanding rational basis standard. This is because SB 157 is not even rationally related to either of the purposes that the state has identified for the law. And the evidence indicates that instead, it is motivated by animus toward the plaintiffs as abortion providing ASFs. There is no connection here to public subsidies or to health and safety. Instead, this law is just designed to single out the plaintiffs as abortion providing ASFs and to shut them down. If this court does not enjoin SB 157 before June 21st, plaintiffs will have to cease providing procedural abortion care as they have safely done for decades. And Southwest Ohio will be without a single procedural abortion provider. This will inflict irreparable harm on the plaintiffs, who will be deprived of their fundamental liberty and property interests in their businesses, and on their patients, who will lose access to procedural abortion in Southwest Ohio. Indeed, the defendants do not even dispute this evidence of irreparable harm in their brief, but instead they merely argue that the plaintiffs should have asked them for guidance about the meaning and application of SB 157 before filing suit. Plaintiffs were not obligated to do so, especially given the statute's clear textual application to the plaintiffs, and therefore this argument does not undermine the plaintiffs' showing of irreparable harm. Indeed, if the defendants want to take the position that SB 157 does not apply to doctors who instruct and train residents and medical students in their hospitals, then they could have said so explicitly in their briefs, but they did not explicitly say this. Finally, the public interest would be served and no third parties would be harmed by an injunction in this case. Therefore, the plaintiffs have clearly met the requirements for a preliminary injunction, and we respectfully ask this court to rule prior to June 21st and grant plaintiffs a preliminary injunction to maintain the status quo and to preliminarily enjoin the defendants from revoking or refusing to renew plaintiffs' licenses or otherwise preventing plaintiffs from providing procedural abortions for reasons related to noncompliance with SB 157. Thank you, Your Honor.
Thank you. Ms. Nirog, whenever you're ready.
Thank you, Your Honor. Plaintiffs in this case bear the burden of proving that they are likely to succeed on the merits of their claims by clear and convincing evidence. They have not met this burden. The rights they claim to be fundamental and thus subject to strict scrutiny have not been shown to be fundamental, and the three cases they offer as proof were decided under federal constitutional provisions, but more importantly, none of those cases applied strict scrutiny, only rational basis review to the suspect legislation in those cases. Asher Investments v. Cincinnati found a property interest in running a business free from arbitrary and unreasonable interference from the government. State v. Cooper considered a regulation prohibiting advertising pursuant to a lawful business. That court determined that although the advertising for sale of Class C fireworks is a property right, the legislative bodies may regulate persons and property in all matters related to public health, public morals, and public safety. And in the Thornburg case, it considered the same type of ordinance that was at issue in Cooper and held likewise. Despite stating that there are decades of precedent establishing a fundamental right to a license and continued operation of a business or profession, plaintiffs only provided 3 of those cases, none of which established the fundamental rights claimed here. Plaintiffs argue that the language of Senate Bill 157 is plain. However, there is certainly a question as to whether the term indirectly reaches as far as they conclude. That is why engagement with the department and even submitting potential doctors as backup physicians is a crucial step before they can come to this court for relief. In their reply, they challenged that defendants do not say whether indirect instruction would disqualify all doctors under plaintiff's interpretation, but defendants do not bear the burden here. They have not been provided any application for a variance to consider, nor doctors to determine for compliance. Based purely on plaintiff's speculation of the import of this language, they seek an injunction from this court. Now plaintiffs say on page 4 of their reply that they are bringing a facial challenge to Senate Bill 157. But plaintiffs then would have to show that Senate Bill 157 is unconstitutional entirely independent of its effect. Nothing in the language signals that it is facially invalid, nor have plaintiffs come close to meeting that burden. And plaintiffs bear the burden of showing they are entitled to third-party standing as well, but instead ignore entirely that they must meet the 3 requirements for third-party standing and advance no argument that they do. They have not shown a hindrance to their clients or a sufficiently close relationship, and since they have no injury in fact, they have not met their burden either. Plaintiffs' interpretation of the language of Senate Bill 157 is speculative, and because there is some ambiguity in the law as to exactly what instruction and teaching is direct or indirect, and the only interpretation we have here is plaintiffs, but the only interpretation we care about is what the Ohio Department of Health, the agency tasked with enforcing the law, what that interpretation is. But the department has not been afforded the opportunity to advise plaintiffs on what doctors this language would disqualify, nor have plaintiffs taken the predicate step of attempting to proffer any doctors at all in compliance or an attempt to show compliance. Here we have no enforcement action, no agency interpretation, and no agency record. We are left only with plaintiffs' speculation, but Ohio law does not allow injunction by accusation, which is all we have in this case. Because they have failed to prove that they will succeed on the merits by clear and convincing evidence, this court should deny plaintiff's motion for injunction here. Thank you, Your Honor.
Thank you. Ms. Hill, any response?
Yes, Your Honor. With respect to the procedural due process, or sorry, with the respect to the interests in liberty and property that are found in those state cases, in fact, all 3 of them find a fundamental liberty or property interest under Ohio law. And although one of them, Asher, is a procedural due process case, so it is not the same standard of scrutiny. It's clear that the Cooper case does not apply, which is an older case, does not apply rational basis. In fact, the court in that case noted that the challenge regulation had some relationship to the asserted purpose, but that the relationship was not substantial enough and thus struck it down under what was clearly a form of heightened scrutiny. In addition, Your Honor, this court has already found that the plaintiffs, that abortion providers have third-party standing on behalf of their patients. They can show that the patients are hindered by the private nature and the impracticalities of bringing a lawsuit in circumstances like this and the private nature of the procedure, and also that they have a close relationship in the sense of a doctor-patient relationship with their patients, and that in any case, as plaintiffs have pointed out, this third-party standing has been found multiple times under federal law, and Ohio state cases say explicitly that they follow the federal standards for standing, including for third-party standing. And finally, we again assert that plaintiffs were not required to seek the guidance of the Department of Health on the meaning of the statute, which itself clearly says that indirect instruction as well as direct instruction, and clearly these doctors are providing one or the other, would disqualify the doctors from serving. There's no compensation requirement anywhere in the statute. And in fact, it appears that compensation is one basis for disqualifying doctors, but not the only basis. And in fact, that the defendants have not disputed that plaintiffs have affidavits saying that they spoke to and researched a number of doctors and were unable to find doctors who comply with the statute's requirements.
I do have a quick question for Ms. Narog. So did the Ohio Department of Health, did they provide any guidance as to what, I guess, the meaning of the word indirectly affiliated, or I can't remember what the other issue was. I know the indirect affiliation, direct or indirect affiliation was an issue, and I think also maybe the issue was around funding and whether or not they were providing free services as opposed to paid services. Was there any guidance that was offered to the plaintiff regarding those issues?
Defendants have had no contact whatsoever with plaintiffs on this matter. They have not been, their consultation and advice has not been sought from them. As is laid out in our briefing, a variance process, it is voluntary. You're not forced to, apply for a variance. So in this case, no advice was given, but none was sought. And the affidavits provided by plaintiffs in this case clearly state that those doctors were not disqualified by the advice or interpretation of ODH. Those doctors were disqualified by plaintiffs because of plaintiffs' interpretation of the statute. We don't have an interpretation or any agency information at all to go by because they just were not sought at all. Plaintiffs did not reach out in any manner to see if that was the actual import of the language of this law. And in addition, the law says very clearly that instruction, whether it's indirect or direct, must be provided at a state medical school or college affiliated with a public hospital or public institution. That also brings into question where the instruction is given. They're saying that doctors are disqualified that might be providing practical instruction at a private hospital. There's certainly some ambiguity there as well. So without any, engagement with the agency processes or the agency that enforces this law, I don't think we have enough information to possibly know how these ambiguities will be enforced by the agency.
I'm sorry, Ms. Hill, was there any response to that?
Yes, Your Honor. So the medical students and residents, medical education is by and large done through practical training. Residents in medical students get their education through working with attending physicians in hospital settings. And the plaintiff's affidavits indicate that the medical schools, public medical schools, all send their students and residents to get their training, by contractual agreements and affiliations with these hospitals. And that's how they receive their medical training. So when the statute says that a doctor is disqualified if they teach or provide instruction to a medical school, that's exactly what they're doing when they are training residents and medical students. And this is why they by and large carry clinical professor titles, even if they don't, engage in classroom teaching or otherwise, work physically in a medical school. So that it's clear, and again, this is in the plaintiff's affidavits, that this is the nature of medical training and residency, and that this is the kind of instruction that the backup doctors, all of the backup doctors that plaintiffs approached, provide.
All right. Okay.
And again, Your Honor, I would just point out that if the defendants want to take the position that this is not a disqualifying fact, they have not said so. They still have not said so even today. They certainly have not said so in their briefs, that this form of instruction does not disqualify the doctors.
Do you have any response, Ms. Nerick?
Yes, Your Honor. Defendants do not bear the burden of providing information as to how it will interpret a hypothetical doctor in a hypothetical situation. All we have before the court on the current motion is plaintiff's speculation as to how the law will be applied. They could have sought advice from ODH. They could have worked with ODH on finding compliant doctors, but they entirely ignored the agency that is tasked with implementing this law and instead came to the court for an injunction. We argue that they should have engaged in the agency process in order to discover how doctors would apply to the requirements of Senate Bill 157.
Maybe I'm mistaken, but I thought in some of the exhibits that were submitted with the plaintiff's motion that there was some communication from ODH about doctors not qualifying. So are you saying that that was just a suggestion, or they should have reached back out and tried to work something out? I guess I'm just trying to get to the bottom of this.
Yes, Your Honor, I understand the question. Those communications were prior to the enactment and actual Senate Bill 157 actually becoming the law in March. Those were prior communications with the agency. And there's little question that some of those doctors would not comply because they actually were professors at a medical school. So we have not had any engagement with them since this court's intervention, and certainly since the injunctions that were already, or the injunction that was already granted in this case.
And I guess my question, and maybe this is also a little speculative, had they reached back out to ODH, would ODH have, I guess, provided guidance to help them get qualified doctors?
ODH certainly would have advised them as to whether particular doctors or particular circumstances would have been in compliance with Senate Bill 157. So there certainly would have been a way for plaintiffs to determine who would comply with the law and who would not comply with the law.
Any response to that, Ms. Hill?
Yes, Your Honor. That's correct. In fact, we applied for a variance. Women's Med Center Dayton applied for a variance and was told that its 4 backup doctors no longer qualified because they didn't meet the requirements of SB 157 because they had professor titles, instructor titles at a state medical school. Once, as of course, the department was trying to enforce SB 157 before it went into effect. Once it did go into effect, plaintiffs, and even before that, were scrambling to try to find doctors that would qualify and to figure out if there were any doctors that would qualify. They have not generally reached out, except in the form of a variance application, to find out whether they can meet those requirements. And there would be no guarantee that the department would get back to us within any specific period of time. The variance applications have generally a 60-day period for being ruled on, and that would not have left plaintiffs much time to get an answer and then continue looking. And again, I'll just emphasize that they still have not said that we are mistaken in our interpretation of the law, or that they take a different position on what the terms direct or indirect instruction mean here.
Okay. All right. Okay. I am going to draft an entry. I should be able to have one on Friday, because I know that time is of the essence here with regard to this particular matter. So as soon as an entry goes on, I will have my clerk notify the parties that that's been entered. Is there anything else before we adjourn?
No, Your Honor, not for plaintiffs.
All right. Okay, well, that entry should be on by Friday, and you all have a wonderful rest of your afternoon.